The subject matter of today's discussion that we have on our table is the litigation on mineral transport services. The issue is quite very specific. You would appreciate it, but in this particular webinar, while we deliberating the issue of this particular litigation, but apart from this, our focus would also be on some general issues that large taxpayers face. So the primary focus would be to deal with this particular issue, but some of the general concept would also be covered, such as we'll be discuss about the concept and difference between the renting and transportation arrangement, right? We'll deal about the situations where suppose you have paid a tax on a particular transaction because on that particular transaction you have a doubt whether it is subject to GST or not. And suppose if tomorrow there is a court order which says that it is not subject to GST, what would be the impact of ITC on the GST that you have paid? We're going to discuss about it. We'll deal the concept of consignment note in detail. We'll see the judiciary situation or the judiciary status of the concept of consignment note under service tax, which has a equivalent sort of relevance under GST as well, right? So these general concepts, which I believe impact almost all the taxpayers, would also going to be covered apart from this, the topic of the today, that is litigation on mineral transport services. So let us begin. So this is the format that we're going to follow. We'll discuss about the transaction that is there on which the litigation is there. Then after understanding the transaction background, in which we also going to cover the general contract clauses that are being entered by these sort of transporters with the mining companies. And after getting the practical, understanding of the contract, we're going to discuss about the GST provisions, then authorities' views, including the CBIC view through the circular that have been notified after 45th GST Council meeting. Post that, we're going to come to our analysis and we'll see that how this litigation is going on and what are our views, how the people who are facing this litigation can litigate their matter before the appropriate authority, be it the Commissioner Appeal or adjudicating authority, or maybe at High Court level. And last but not the least, we'll conclude the matter and we're going to have a Q&A session. So typically, there is a mining company and there is a transporter. They enter into a contract whereby generally two sort of services are provided. First is loading of coal. I'm specifically talking about the coal because this litigation primarily pertains to coal and sand. So at a first stage, you load the coal on the vehicle, etc., and then you transport that coal using truck, dumpers from mining area to the railway sidings, and this is called as a transportation. So there are two sort of services. First is loading, and then there is a transportation. The general terms of the contract which entered by these sort of transporters with these mining companies generally are PSU, right? So there would be a loading as we discussed, and there would be a transportation and unloading at a railway sidings, and this entire area is within the mining areas. The contract specifically provides that the consideration would be linked with your quantity that you will lift from the the mining area to the railway siding, right? It specifically provides that how much quantity you would need to transport from one place to another place, right? And the contracts also stipulates that how much quantity you would need to transport on per day and per week basis. This is very important when we'll be discussing about the concept of renting versus transportation. These facts we're going to reiterate. So it is important that we should understand each of these clauses separately. The second is that if you are transporting the coal less than the specified quantity, because we have a limit on per day, per week basis. So if there is a shortfall, the contract also provides the penalty clause or LD clause, right? The maintenance of the private roads, apart from the roads which are maintained by PWD or the roads which are maintained by these mining companies, it is the responsibility of the contractor generally. Rates generally don't changed, except if there is a change in the diesel price or petrol price, etc. The transporters are generally required to provide the details of the tippers, dumpers, trucks which you're going to use to transport these minerals from mining area to railway sidings. The list of these trucks, etc., are provided in advance to the mining company. The contractor is required to deploy his agent or representative, at that particular location, who receives the instruction from the concerned person of mining company, and accordingly work to transport these coal to railway sidings, right? The contracts also generally provide that the trucks or dumpers that you're going to provide to the mining company, it would specifically mention these points on the truck itself, that this is on this company's duty, X Coalfield Limited duty. Area within which that particular truck would want to operate, it needs to be mentioned on the truck. The registration number of the vehicle and the period of contract. This should explicitly come on the truck. Okay. So these are the general terms that are entered by the transporter with the mining company, and accordingly the transportation services are being provided. So before moving forward, I want to take few assumptions, or you can call it as a disclaimer, before providing specific comments relating to taxability. The first and foremost is that our webinar was focused only on the litigation relating to transportation services. We're not going to talk about the loading charges, because if you see the contract which they enter, they primarily perform two sort of services. First is the transportation, and second is the loading of the goods. As far as the industry practice is concerned, these transporters are paying GST on the loading charges at the rate of 18%. The litigation is primarily on transportation charges. So we're not going to comment, or we're not going to discuss about whether the transportation and loading can be treated as composite supply or not, how to treat the loading charges with the transportation charges. We'll not discuss about it. We'll restrict our analysis only relating to the litigation for transportation charges. Our discussion would primarily be on the merits of the case. So we're not going to discuss whether a limitation period would be applicable or not. The show cause notices which are issued by the authorities, are they properly structured? Are they issued within the four corners of the law or not? What would be the applicability of penalty if tomorrow the demand is quantified by the courts, etc. So our focus would be primarily on the merits of the case. Last but not the least, very important, the discussion would be based on the general terms of the contract that we have just discussed in the previous slide. So your contract clauses may get changed, and the views can also be changed. So while concluding the views relating to the taxability, one should properly take care of the points that we're going to discuss in the upcoming slides. So general reference or general views cannot be adopted in respect of all the contracts. Specific terms needs to be reviewed before commenting anything. Let us forward. So relevant legal provision. So currently the litigation primarily revolves around whether the activity which these transporters perform, are these services qualifies as transportation services, or is it a rental arrangement between the transporter and the mining companies? So we'll see the classification of transportation under GST, and we'll also see the classification of rental, and we'll try to understand the legal provisions of it first. As far as the rate structure is concerned, you can see on your slide, The red boxes indicate that in these scenarios, the ITC is not available, and the green boxes indicate the ITC is available. So at the beginning of the GST, the tax structure that was introduced for the GTA sector was 5% GST under reverse charge. On this, the credit was not available to the GTA. With immediately after 1.5 months approx, on 22nd of August 17, the government had introduced two tax structure rate for this service providers. One is reverse charge, 5% reverse charge, and second was 12% under forward charge mechanism. In reverse charge mechanism, the credit was not available. However, in forward charge mechanism, the credit was available. Recently, in July 2022, the government had introduced three separate tax structure. If you see, the comparison between second and third, they had introduced one more slab whereby the transporter would have an option to pay 5% GST under forward charge mechanism. So this is the difference between 2 and 3, right? As far as the rates are concerned. Now, if you read the exemption notification in the law provides that transportation of goods by road are exempted from GST. So services that are provided, the services of transportation that are provided on road are exempt from GST, except in two cases. One is services relating to the GTA, and second is the courier agency services. So apart from this, all sort of transportation by road are exempt from GST. And one more point, as far as the reverse charge is concerned, for the period after 27th of August 2017, we had two tax structure, 5% under reverse charge and 12% under forward charge. The law specifically provides that if GST is not paid by the supplier under forward charge, then there would be a reverse charge. So the primarily liability to pay GST on GTA services was on the recipient. If the supplier had paid the tax under forward charge mechanism, then the recipient is absolved from his liability. So the primarily liability to pay GST during this period was on the recipient, not on the supplier. This is specifically mentioned under the rate notification. Moving forward, as far as the rental arrangement is concerned, it was 18% GST from 1st July 2017, and recently in July 2022, the rate was reduced to 12%. The credit was available in both these periods. So yes, our discussion would be primarily for financial year 17-18, 18-19, 19-20, 20-21, and for 2022 as well, but up to 18th July 2022. Because after 18th July 2022, we all know that the tax structure for GTA industry was altogether get changed, right? So, and litigation also is happening for the period up to 2021, if I'm not wrong, right? So this is the tariff description. If we read the rate notification, I'm not reading it, we have already discussed it, right? So there were three tax structure during 22nd August 2017 to 18th July 2022, 5 or 12% for GTA, and for rental arrangement, it was 18%. This is very important. If we read the explanatory notes of the scheme of classification, which is annexed to the GST rate notification, heading 9966 provides what is, so to get it covered under heading 9966, that is rental arrangement, you need to satisfy the condition of this explanatory notes. Now it says that the service code includes rental of buses, coaches, truck, and other motorized freight vehicles, right, with or without operators. So for getting covered under 9966, it is not mandatory whether you are providing an operator with the vehicle or not. This is not a precondition. We had judgments in past making differentiation between hiring and renting. The primarily, argument was that since there was no operator, you cannot call it as the renting, or you may call it as a hire, etc. So as far as the renting is concerned, under 9966, the having an operator is not a precondition. First. Second, the vehicle is given for a period of time. It must be linked with the period of time. For example, you are giving the vehicle for 6 months, for a month, for 2 months, etc. So you are giving the vehicle linking with the time, not the distance. And therefore, it says it is not generally dependent on distance. You have hired a vehicle by saying that, okay, I have to transport from Delhi to Mumbai using this particular vehicle. And this is the distance. It's a transportation arrangement because you have not taken the vehicle basis the period of time. I need this vehicle for 15 days. For purpose, that is on me. The control is on me. How I will use it, what I'll use it, this is on me. But if it is on based on the distance, then it would be a transportation. It is not a rental arrangement. So first, the condition of operator is not there. Second, it should dependent on the period of time. And third, it says the renter defines how and when the vehicle will be operated, determining schedules, routes, and other operational considerations. So it is totally on the renter, that is receiver, how he'll gonna use the vehicle for his purposes. Right, so the entire operation consideration, the control relating to vehicle would be with him. So if we summarize heading 9966 to get it covered within this particular heading, 3 conditions needs to be satisfied. First, the contract should be based on the period of time. There is no condition of having operator. Third, the control of vehicle should be available with the renter. He'll define how it is used. The entire operational considerations, the right relating to it, would be with him. Now, if you see this classification, the explanatory notes, we have seen 3 important conditions. But is not this particular explanation is not providing anything whether the possession of the vehicle, is it mandatory to call a particular arrangement as renting or not? It's very important, very, very important. I'm repeating. This particular explanation is not talking about anything whether giving a particular vehicle on possession, the possession of it should be given to the receiver. Is it mandatory to call a transaction as renting or not? It has not been mentioned in this particular explanation, right? We'll see about this particular condition as well in a upcoming slide, whether having a possession is a precondition to call a transaction as renting or not. Now, what the authorities are taking the argument, authorities are saying that the tippers, dumpers, loader, trucks, etc., which you are giving to the mining lease operators, this is called as hiring of the vehicle. Expenses of fuel, etc., are generally borne by the mining lease operator. Vehicles with the driver are at the disposal of the mining lease operator because we have seen the contract. He decides the schedule, etc., relating to the vehicle, how you want to use it. So they are saying because the driver which the contractor is providing to the mining lease operator, that driver would work according to the instruction of the mining lease operator and during the entire period of the contract. They are saying this is nothing but a time charter of goods carriage or a rental service of transport with the operator, which would fall under heading 9966, that is renting, and 18% GST would be there. This is not a transport of goods by road. Now let us understand the difference. If I say that this arrangement is a transportation of goods, then it can either be exempt or it can be subject to GST and the reverse charge during the concerned period. And the mining lease operator is required to pay GST. When it would be exempt, if it is not qualifying as a transportation service. If it is qualifying as a transportation services and the transporter is qualifying as a GTA, then mining company would pay GST and the reverse charge. And this is something which is happening in industry. The mining companies were paying GST and the reverse charge at the rate of 5%. there were divergent practices. In few regions, people were saying that since the transporters are not issuing any consignment note, these services are exempt. There, the recipient even were not paying GST. But in few regions, we have seen that the mining companies are paying GST at the rate of 5%. But we have hardly seen any scenario whereby the transporters are paying GST at the rate of 18%. So department is saying that transporter is required to pay 18%. They are disregarding the GST liability that the recipients have paid, right? So this is the entire controversy. Now, the matter was represented or highlighted to the GST Council, and they had deliberated the issue and they have come up with this clarification. The first 3 points are same, which we have discussed, the arguments that the authority is taking. Point number 4, the authority is saying the person who takes the vehicle on rent defines how and when vehicles will be operated. He determines the schedule, routes, and other operational consideration. It is not a transportation of goods. Very important, the conclusion part. Renting of trucks with a driver for a period of time is a service of renting of transport vehicle with operator falling under 9966. It is not a transportation of goods by road. So what they are saying, they are linking the renting arrangement with the period of time that we have discussed. It's a precondition for heading 9966 that if you want to get it covered within this clause or this entry, the arrangement should be for a period of time. It should not be linked with the distance, etc. So they are saying in conclusion, when you give the truck on rent for a period of time, then it would call as a renting. It is totally in aligned with the entry that we have discussed. But we have a few questions now. So we have seen the contractual arrangement. We have seen the legal position. We have also seen the arguments of authority and the circular. Now let us, deep dive on the very few important questions which will help us to conclude what is the exact nature of these contracts. First question is just give me a second, sorry. Yeah. The first question is the mining operator in control of the vehicle, including determining how and when they'll operate the vehicle, what would be the route, and other operational decisions, etc. Is this control exercised unilaterally or is it mutually agreed between the parties? So when we say that there is a rental arrangement, suppose I have given up immovable property to you to use it for your own purposes. Now you are my tenant and I am the landlord. How you will use the property, it is totally upon you. Under the contract, I can put certain restrictions that, okay, you will not going to use in this way. For example, you will not use the residential property for commercial purposes. It's a restriction. It's not a, control that I am exercising in this scenario, right? When you take a property on rental basis, the immovable property, the entire control relating to property lies with you. You have a right when you want to use it, how you want to use it. You will not damage the property. That is fine. It's a separate contract clause. But I'm not controlling you anyways. Now, if we compare this scenario with our arrangement, when we give the vehicle to the transporter, the mining operator, they don't independently decide that how to use this particular vehicle, what would be the route, the operational considerations. It is mutually agreed between the parties. So the first question that arises is that, is this control exercised unilaterally or not? Second, is the vehicle given to the mining operator for a specific time period, such as 10 days, or is it for a specific quantity? That is, okay, you have to, lift this particular metric tons of coal from mining area to railway siding. So we have not given the contract, we have not allotted the contract for a period of time. The contract is primarily based on the specific quantity that, okay, boss, you have to lift this 1000 metric ton of coal from mining area to railway siding. Right? Third question, once the vehicle is deployed at work, Does the supplier lose the ability to operate? This is quite practical. This needs to be, identified, or this needs to be proved. But the question is important. Does the supplier loses all the rights relating to operational considerations, or the rights relating to operation of the vehicle? Important. Very important question. How the contract is linked as far as the consideration is concerned. In our scenario, we have specifically seen that the transporter is required to uplift a specific quantity of coal from mining area to railway siding. And the consideration is based on that particular lifting of the coal. Now, the contract also provides that you need to make sure that on per day or per week basis, you are also transporting this much of material. If you're not transporting, then the penalty would be there. So overall, the contract provides that your consideration would be linked with the transportation, how much quantity you are transporting. Vis-a-vis in a rental arrangement, whereby I would be giving a vehicle to you and you can use on your own how you want to transport, whatever quantity you want to transport it. You cannot make me responsible for that. If you are making me responsible, if my consideration is linked relating to whatever I am transporting, whatever I'm lifting from one place to another place, then how it can be called as a rental? This is another important question. The last but not the least, whether any possession of vehicle is given by the contractor to the mining operator. I believe no. Why? Because I am giving you a representative, I am giving you a driver, but I'm not giving you the vehicle. So how it can be called as a renting? These are some important points that needs to be addressed, that needs to be put forth appropriately before the concerned authorities to make your case, whether it's a transportation or not. Right. So this is something which we have analyzed in context of the arguments and the circular that authorities have issued. Now let us come to the questions relating to taxability. So what is the exact nature of this arrangement? Is it renting or is it transportation? We'll see. Second, if my transaction qualifies to be a transportation arrangement, whether it is merely a transportation arrangement or is it a transportation by GTA, because we know the difference. If it's merely a transportation services, it is exempt from GST. But if it is transportation by goods transport agency, then there would be GST liability under reverse charge, and the mining lease operator is required to pay GST. So we'll see it, because again, it's very important. I'm just reiterating the fact that in few regions, even the mining lease operators have not paid GST under reverse charge. So they need to determine whether the transaction, if it is qualifies to be a transportation, is it merely a transportation or GTA, right? And if we see the difference between transportation or transportation by GTA, the crucial difference that comes is that whether the supplier, the transporter, has issued any consignment note or not, which practically these suppliers don't issue, these transporters don't issue. So we're going to discuss about, is there any requirement under GST law to issue consignment note in this case? We also have a litigation in the GST that has evolved up to Supreme Court level. We're going to discuss that litigation, and we'll also analyze whether that particular litigation would have an impact under GST or not. What would be the implication on mining companies if tax is not paid under reverse charge? This I've already discussed. What would be the impact of reverse charge payment made by mining companies on suppliers' liability? Suppose tomorrow, if authority says that, okay, you need to pay a GST under forward charge, it's a rental arrangement. Let us assume for time being, then what would be the impact on supplier? Suppose the mining company has paid GST at the rate of 5%. Well, the department would ask, or the court will conclude, that differential liability needs to be paid, or is it like they need to pay 12% in its entirety and 18% in its entirety, and the 5% GST which the mining companies have paid, they have to claim it separately? We'll discuss it about also. Last but not the least, what would be the exposure of ITC availed by mining companies? if the courts determine tomorrow that tax was not payable under reverse charge, because today I've paid GST under reverse charge and I've claimed the input tax credit, can the authorities argue that since it was not a tax per se at a first stage, so the credit of it would also not be available? I'll discuss about it also. So let us start renting versus transportation. So what I will do in next 2 to 3 slides, I'll be discussing few of the very important judgments that explains the concept of renting and transportation. That will enable us or help us to conclude what is the exact nature of renting, and basis that will answer the questions that we have just discussed in the last slide. Okay, so here's the case. Madras High Court, they held that the term hire is not defined under income tax. So we have to take the normal meaning of the word hire. Normal hire in the contract by which one gives to another temporary possession and use of the property other than money, etc., and the later agrees to return the property after the expiry of agreed period. So in hiring contract, see, there is a minor difference between hiring and rental. We'll discuss. So here, so let us assume for time being that hiring or rental are same, right? In hiring, what Madras High Court held that there would be a temporary transfer or temporary possession with the recipient of that particular property, right? Okay. Dhanlakshmi's case, Sastat, Mumbai. Control and possession both are needed to qualify a transaction as renting, right? So tribunal said assessee was providing vehicles to BSNL per kilometer basis. Driver was provided by the appellant. A prima facie view was that this is not a rent-a-cab service, right? So control and possession both are mandatory. Kuldeep Singh's case, Sastat, Chennai, I guess, providing vehicle to companies for transport of their employees or children of employees, and when getting payment on per trip basis, depending on the distance or time, not period, is not renting a cab. It is providing a transportation service and is not taxable under erstwhile law when we had the clause under positive list regime relating to rent a cab service. Shiva Travels, whether giving a driver would make any difference, we have already seen that giving an operator is not a precondition, and same view was held by the tribunal also. Cab given with or without driver will come under taxable service. Argument of assessee was that cab was never given on rent, as a control over cab was capped by the cab owner himself. Right. RS Travels case, control and possession both are needed. Again, we have seen this particular point, and we have this recent Uttarakhand High Court judgment, where again the same point was held that unless control of vehicle is made over to the hirer and he is given possession for howsoever short period to deal with the vehicle, there would be no renting, right? So these are the judgments relating to rent-a-cab, rental arrangement, whereby what we have seen that you would need to give a control as well as possession relating to the subject property to the recipient in order to call this arrangement as a renting arrangement. If you are merely giving a control, not giving a possession, or if you're giving a possession but not the entire control, then you may not call it as a rental arrangement. It can be hiring arrangement, or it can be a transportation arrangement. Now, the jurisprudence that evolved under the service tax relating to this particular sector, we're going to discuss about it. So prior to June 2007, under the positive list regime of service tax, the department used to argue that the services which these transporters are providing, this is cargo handling services. In 2007, the positive list regime had introduced a separate entry called as mining services. So department used to argue after this period that this services qualifies to be a mining service, because the definition of mining service was inclusive, that mining includes etc., etc. So they were saying that since the transportation is relating to mining, and therefore it would call as a mining service. After 30th June 2012, we had a negative list. Department 3 used to argue that it qualifies to be a mining service up till 30th June 2017. But interesting part is that irrespective of the period, the courts have categorically held in all the cases that these services are transportation of goods. This is not neither a cargo handling nor mining services. They have categorically held that this is transportation of goods. I'm just reproducing these judgments. So in this particular case, the Delhi Tribunal for the period 1st June 2007, prior to 2007, they held that the activity, assessee only engaged in activity of transportation and not involved in loading or unloading of aforesaid goods from wagons or motor vehicles. Undisputedly, service tax under GTA being paid by the recipient and accepted by the department, the assessee is not liable to pay tax under cargo handling services. So we have this judgment, we have this some sort of clean sheet that this activity cannot be called as a cargo handling service. So period after July 2007, up till the negative list, we have this Supreme Court's judgment, very important, Singh's transporter case. In this particular case, the High Court in its order categorically held, that the arrangement between transporter and mining company, it is transportation of goods by road service. I'm reading, transportation of coals from the pit heads to the railway sidings within the mining area is more appropriately classifiable under the heading of transportation of goods by road and does not involve any service in relation to mining of mineral oil or gas. Right, this is an important judgment because it's a judgment of apex court, but this pertains to pre-negative list. Now after pre-negative in negative list, we have this judgment of Delhi Tribunal which says that for period prior to negative list, the Supreme Court explicitly held, we have read this judgment above, that this is a transportation of goods by road. However, it did not provide that whether transporters can be referred as GTA or not. In the given case, the same was recognized and the controversy restricted to whether transporter qualify as GTA or not. Right. So after June 2012, when Supreme Court had already held that this activity per se is a transportation arrangement, they had not specifically mentioned in their order whether the transporter would qualify as GTA or not. This Delhi Tribunal's judgment, Arjuna Carriers, they held that this activity, they had recognized that the Supreme Court has not categorically provided that the transporter can be qualified to be a GTA or not. And for the sake of understanding the definition of GTA under service tax and under GST, they both are same, 100% same, right? So the jurisprudence that had evolved relating to GTA under service tax can be applied under GST as well, as far as the definition is concerned, right? So tribunal in this case recognized that the Supreme Court had not specifically mentioned that these transporter can be qualified to be a GTA or not, right? They held that in this judgment, since the transporter are not issuing the consignment note, we cannot call them as a GTA, right? So what we have seen up till that the transporters can, so the arrangement between the mining companies and the transporters are primarily of transportation. This is something which have been held under the erstwhile law, right? Again, you can apply this judgment, but it's very important that you should analyze the terms of the contract before relying on these judgments. And you should make your case on merits by applying the principle relating to the differentiation between renting and transportation. Post that, the reliance should be placed on this judgment. If you are going to apply this judgment directly before the authorities, I believe they will not going to give any sort of benefit to you, because they'll simply say, and they are saying these days, that this judgment pertains to erstwhile law and reliance cannot be placed directly. So first of all, you have to prove the arrangement based on the terms of the contract, and post that you should rely on these judgments of the erstwhile law. Now let us see what is the difference between a mere transportation and transportation by GTA. So GTA has been defined as any person who provides services in relation to transportation of goods by road and issues a consignment note, okay, by whatever name called. Now, consignment note is not has not been defined under the GST law. We all know this. But if we read the erstwhile law, service tax law, rule 4B of the service tax rule, it used to define the consignment note. It used to say that consignment note means a document issued by a GTA against the receipt of goods for the purpose of transportation of goods by road in goods carriage, which is serially number, contain the name of consignor, consignee, registration number of the vehicle, detail of goods, origin, destination details, etc. Right? All about the transportation arrangement and between the parties. It is mentioned on the consignment note. So, but if you see the definition of GTA and the definition of consignment note, you will find a circular inference between these two definitions. Why? The definition of GTA says that a person, the transporter who issues a consignment note is a GTA, and the consignment note has been was defined as a document issued by GTA. So there is a circular reference between both these definitions, because there is under the law there nowhere it has been defined when to issue a consignment note. The definition of consignment note merely says that it is issued by GTA, and GTA says the definition says that the person who issues a consignment note, but who is required to issue a consignment note was not provided in this service tax law. It has also not been provided in the GST law, right? Okay. Now, if you see the requirement of issuing the consignment note, we have this act called as Carriage of Goods by Road Act 2007. It provides that the common carrier is required to issue a good receipt, right, for the consignment. The document is prima facie. Section 9 of this particular act provides that this document is a prima facie evidence of the weight or measure and other particulars of goods and the number of packages, etc., that you are taking on the vehicle. It also provides that such goods receipt which you are issuing shall include an undertaking by the common carrier about the liability for loss or damage of the consignment. So what you are doing, the document which you issue under this particular act, you primarily takes a responsibility because you are a bailee under the contract of bailment. The goods are provided to you. So you have taken a responsibility relating to goods that you're going to transport from place A to place B. And if anything happens in between due to my fault, I'll be responsible to compensate you, right? Okay. So the question that comes now in context of GTA is that first, whether payment slip can be referred to as a consignment note or not. What happens in this industry is that when you lift the coal from mining area to truck, because your consideration is linked to the quantity that you are transporting, so these transporters issue a payment slip to the recipient. They provide that, okay, boss, we are transporting this much of vehicle, this much of quantity of mineral or coal from this place to the other place. So they issue a payment slip. The question is whether the payment slip can be called as a consignment or not. The answer is no, because payment slip merely provides the details about the goods that you are transporting. That particular slip or that particular document does not provide anything about the consignor, the consignee. It does not provide the undertaking that if something happens in between, then I'm responsible. It's merely a document to prove that how much quantity you are transporting. So therefore, the payment slip cannot be referred to as a consignment note. Second question is that if I'm not issuing the consignment note, then whether mining operators are absolved from the GST liability just because I'm not issuing the consignment note as a transporter, right? So transaction is transportation of services. I'm not issuing any consignment note to the recipient. Department is saying that since you are not issuing the consignment note, that would not change the fact that you are liable to pay GST under reverse charge. The question that comes is that whether non-issuance of consignment note by the transporter absolves the mining operator from GST liability just because you are not issuing this particular document. And we have seen that this document is not mandated under the erstwhile service tax law and also under the GST law. It's a very important question, right? So let us understand this now. So first of all, let us understand the true nature of the consignment note. So consignment note is issued to account for the liability in case of damage or loss of the consignment. The transfer, it transfers the lien of the goods to the carrier, making them responsible for the safe delivery. It is only GTA who assumes the agency function. And if you read, the budget, then during the positive list regime, when the GTA entry was introduced, in that budget, the finance minister, the memorandum explaining the finance bill, had specifically provided that individual trucks, tempo operators who do not issue consignment note are not covered under GTA service because they don't issue consignment note, because they don't assume agency function, right? Under GST, the Rajasthan AAAR held that where liability for such consignment is resumed by the carrier and lien is transferred, then mere non-issuance of consignment note would not result in non-recognition of such carrier as a GTA, and recipient is required to pay GST under reverse charge. Even if you see the Madras High Court's judgment under the erstwhile service tax law, there the High Court also held that the recipient of service could not avoid payment of service tax, taking the advantage of GTA's failure to issue consignment note. So this was something held under the erstwhile law. Very important, if we see the jurisprudence that has been evolved relating to this particular sector in context of consignment note, this is deviating from what we have discussed up till now. What we have discussed up till now is that if the GTA fails to issue any consignment note, then it cannot absolve the recipient to pay GST under reverse charge. Fine. But the judgments that are there on your screen relating to this particular sector, the mining transporters, transportation of mining services, in these judgments, the tribunals over the period held that since the transporters are not issuing any sort of consignment note, therefore, the recipient mining lease operators are not required to pay any service tax under reverse charge because the services does not qualify as GTA services. Very interestingly, the question that we are discussing in this presentation, that whether consignment note can absorb the liability or not, this matter went to Supreme Court also. In the case of South Eastern Coalfields, the matter is pending as of now. But in this particular case, no stay was granted by the Supreme Court. And if we see the judgments that are coming these days also, they are saying clearly that if the transporter is not issuing consignment note, then the mining lease operators are not required to pay any sort of GST under reverse charge, right? So we need to wait for the Supreme Court to decide on this matter whether non-issuance of consignment note can really absolve the recipient from paying the GST liability or not. Impact on the mining operators. Let us assume that the judgment comes in favor of transporters, whether there is any risk on mining operators who have paid GST under reverse charge. So suppose the courts tomorrow held that this activity qualifies to be a renting arrangement, then whether there is any risk that the mining companies are carrying, are they whether there would be an issue relating to their input tax credit or not. In this particular issue, the courts over the period of time held that if something has been paid by a taxpayer and the department is not arguing the output liability or the liability which they have paid, then irrespective of the fact that whether such transaction qualifies to be the definition of input services under the Senate credit rule, etc., the credit cannot be denied. So relying on those sort of judgments, we can say that if the mining companies have paid GST under reverse charge, then there is a very low chances that the credit can be questioned by the department, right? Okay. Concluding the today's session, first of all, we need to see the specific agreements for forming a precise view whether the arrangement between the transporter and the mining companies is it a transportation arrangement or a rental arrangement. Importantly, the circular that the CBIC has issued, it holds a significant authorities for the tax authorities. So they're not gonna listen your arguments. They'll simply rely on that particular circular and they'll issue a demand order. And we strongly believe that this matter will only going to be solved by the high courts. And if in between we have a tribunal, then tribunals will also hold the same sort of view, we believe. If the service recipient has not paid the tax under reverse charge, then the matter would be settled at a Supreme Court level. Right? Why? First, we believe that it's a transportation arrangement. Second, recipient is required to pay GST under reverse charge or not. It depends upon whether the transporter qualifies to be a GT or not. And since this question of law is pending before the Supreme Court, therefore, the the liability, whether you are liable to pay GST under reverse charge or not, would only be closed by the Supreme Court. It is requested to CBIs to reconsider the clarification because they have not relied any sort of erstwhile jurisprudence while concluding the arrangement between the mining companies and the transporters. So it is requested to reconsider the clarification. Last but not the least, contractors and mining operators are advised to examine their contractual obligations regarding the burden of GST from their contracts. So if there is a specific clause in the contract that if liability comes on me, then I can recover it from you, etc., that needs to be analyzed while deciding the commercial contractual liability relating to GST. Generally, these contracts are GST exclusive contracts. So if liability comes, then you can ask unless or until there is a specific condition under the contract that if tomorrow any liability comes due to misclassification, then recipient would not going to reimburse. That needs to be seen specifically. This is all from my side. We can discuss the questions. Nitin ji has asked one question. In case of renting of vanity van, the same would be qualify as a renting for transportation of passenger, or it would be a rent-a-cab service. Such vehicle is considered as a motor cab as per Motor Vehicle Act. Such vanity van may be provided with or without driver based on per kilometer or on contract may be executed for charge plus reimbursement of fuel. In the above scenario, what should be the levy views solicited? So again, it would depend that whether you are providing your vehicle, how you are providing your vehicle. If you are providing your vehicle for a period of time, and the control relating to the vehicle have been given to the recipient along with the possession, then there are high chances to call it as a renting. If you are giving the vehicle without giving any control or possession, for example, suppose there is so if you see the difference between a vehicle used for transportation of goods vis-a-vis vehicle used to transport the passengers. There, in passenger transportation vehicle, generally the possession comes when the recipient sits in it, apart from driver. But in goods transportation vehicle, because the recipient would not going to sit in, or the person, the recipient would not going to sit on it, then we generally see that who is driving the vehicle, who is controlling the vehicle. If person who is controlling is of you, that is recipient, then it would be, it signifies that it's a rental arrangement. If it is not, if the possession is not given and it is with you, then it's highly debatable to say it's not a rental arrangement. It's a transportation arrangement, right? Transportation of coal from mine to surface coal can also be treated as renting, or is it transportation coal from mine to surface coal yard? So depending upon the terms of the contract, how you have drafted, you need to apply the principles that we have discussed in our presentation, period of time, control, possession, etc. That needs to be seen. Accordingly, you can decide whether it is a renting arrangement or a transportation arrangement. If GTA is not the owner of vehicle, means that GTA is hiring vehicle from another transporter, then he is giving vehicle to other GTA. Can we claim exemption of 22B? GTA is not the owner. Need to cross check, ma'am. I'm not sure about as of now. We'll revert to you. You can write at on our mail. You can just drop your query on the second mail, sunil.kumar@tmsl. I'll check and revert to you. Done. I think we are done with the questions. Thanks to all of you for joining to today's webinar. I sincerely appreciate for listening me till the end. In case you have any query relating to this particular issue, you can write us on the mail IDs that we have provided on our presentation. And thank you. Thanks for joining today's webinar.